Good morning, doctor. After this period of legal study, I also have a central concept and their own understanding of the law. Next, I discuss the type of law I learned and somewhere about this. First of all, what is law? Which is important that this is our first step in the learning law. To understand the law is a set of the rules designed to regulate the conduct of the people of the country, perhaps center types of the behavior which requires people to compensate each other financially and spiritually, and what duties the citizens must perform. The law has specialist regulatory divorces, national parliament and the courts. Laws are points between public law and private law. The meaning of the public law is to address the relationship between the citizens and the countries. Private law is defined as addressing the relations between citizens in order to compensate the victims rather than punish the defendants. In life, we may always sign the contract, but do we really understand the consequence of the contract? A contract is an agreement between civil subjects creating, changing, and terminating civil legal relations, with at least two parties to whom the person making the contract is called the offerer, and the party making the proposed offering. Both parties are free to accept or reject the other's terms. It is important to consider whether to write it clearly before signing the contract, because once the parties agree, the contract will become a legally enforceable commitment, which has a legal effect. During the commencement of the contract, the parties must perform their duties under the contract and respect the rights of the other. A failure or refusal to perform its duty amount to a breach of the contract. Therefore, the innocent party may take action against the defaulting party, have a legal resource. The status of the commercial contract may be valued, void, and voidable. In Chapter 5, I'm aware of the details of the commercial contracts. One, who is able to enter into the contracts to determine how the terms and forms are important in the contract. The parties to make a contract shall have the qualification and the legal capacity to act. Article 11 states that qualified to act contracts is the age of the 18, and the sanctity is not limited by any law, but in some cases, the signing of the minor contract can also be recognized by law, because the law can better protect the rights of the minor. So it is necessary to judge whether the contract is valued according to the situation. Under the contract for necessary actuals with a minor, he may sell the necessity for the contract building on both parties. Service contracts are apprentice contract scholarship, marriage contracts in which side for minors' participation are valued. 5 factors will invalidate the contract: corruption, undue influence, fraud, misrepresentation, mistake. In a valid contract, it consists of the two parties, one express or implied, two condition or warranties. Express terms is a term used in the contract law to express the consent and the acceptance of the parties to the contract. Express provision is generally building on all parties. The implying terms were words or terms which the courts held should be included in the contracts. That is not expressly provided in the contract. Therefore, the drafters of the contracts usually avoided the use of the implied clauses. Most of the parties do not want to rely on the court's interpretation of the terms of the contracts. Another party of the term is considerations guarantees based on the central obligation imposed by the parties, terms and the provisions, and the conditions that the indispensable and needs to be met. Guarantee refers to the guarantee of the product quality, adaptability, and the performance provided to the buyer. In eight chapters, I learned that discharge of the contract implies termination of the contractual obligation. This is because when the parties originally enter into the contract, the rights and the duties in terms of the contractual obligation were set up. Consequently, when those rights and duties are put out, the contract is said to have been discharged. Once the contract stands discharged, parties to it are no more liable, even through the obligation under the contract remaining incomplete. My understanding of the issues of default relief is that the other party suffers the damage due to the breach of the contract, and the defending party needs to give a center compensation. The liability for breach of the contract is the civil liability in process of the contract after the contract is established according to law. About law of agency, principal and agents are also common roles in life. Section 113.7. An agent need not be a major or sound mind. If he is minor or unsound mind, he would not be liable towards his principal for acts done as agent. Express appointment of the principal may be written and oral. The happening of an event which the render of the agency unlawful, the agency may be terminated. Finally, I sum up that the few days of the law study and life, we have systematically learned the concept and the source of law and the many details of the contract law. I hope I can well use this knowledge to life in the future. Thank you, the doctor, for your hard work.